Yeah, Brandis, thanks. The Texas abortion case is back at the Supreme Court 2 months to the day after it went into effect. The law empowers private citizens to enforce a ban on abortions as early as 6 weeks of pregnancy. This is the second time the law has come before the High Court. In a ruling 2 months ago, the court, by a 5-4 vote, allowed the law to go into effect pending further action. And joining us to talk about today's Supreme Court arguments are Carolyn Shapiro, professor of law at Illinois Institute of Technology, Chicago-Kent College of Law, and Peter Breen, vice president and senior counsel with the Thomas More Society. Welcome, both of you, back to Chicago tonight. Peter, I paraphrased it at the top, but remind us again the thrust of this Texas law. Peter, I think you're on mute there.
Sorry, I've got little kids running around in the background. Yeah, this Texas law allows private individuals to enforce a 6-week, post 6-week abortion ban. So it's unique in that it's got private individuals doing it instead of the government officials. And so the argument for folks who are on the pro-life side is that, well, if you want to challenge it, you've got to go through the Texas state courts. On the abortion side, they're saying, no, we want to go to federal court and do a pre-enforcement challenge. And so that is what gets us up to the Supreme Court today on this issue of federal court jurisdiction, which you take classes on in law school. It's so complicated. So it's a little difficult of a topic, but it is a very important one for practitioners.
Okay, so whether this belongs in the federal court system is what the Supreme Court is hearing arguments on today. Carolyn, summarize those arguments for us, the arguments that justices heard today.
Well, the argument that the case should be heard now in federal court is that this is, first of all, an unprecedented law. There's never been a law like this, where the state is essentially outsourcing its desire to violate people's constitutional rights. It would be as if a state said, I could sue somebody for any time they bought a gun, or I could sue a gun dealer any time they bought a gun, but not having any state activity in the enforcement other than passing the law and then opening the courts. So the argument on the part of the plaintiffs the plaintiffs who provide medical care to women is that law has such a significant chilling effect. It's a $10,000 bounty at a minimum, plus attorney's fees, for anybody who sues someone who has either aided and abetted an abortion, which is an undefined term, or actually provided an abortion, any doctor who does that, that it has had such a chilling effect that basically abortions are not available right now in Texas. And that is as if Texas had passed a law saying that abortion is illegal at 6 weeks of pregnancy, which it would clearly violate the current Supreme Court precedent.
So it's a different situation because it involves citizens enforcing the law here. Peter Breen, does this mean that there would be a separate hearing on the merits of the law itself once the Supreme Court decides whether or not that this belongs in their jurisdiction?
And there's already a state court case pending on this one. So it's not that they're not going to get a hearing. It's just a matter of where do you actually hear it and when. So do you hear it beforehand? Do you get a federal court hearing? But again, they've got a state court action already pending. And again, as I understand it, there's not a single judge in the state court system in Texas that has upheld the law. So this is a different situation than if you said, oh, the whole judiciary in Texas is ignoring Supreme Court precedent. They're not so far. And I would say, this law is a very sensible regulation. It's a heartbeat bill is what we call it in the abortion parlance. So it would prohibit abortions after a heartbeat, supported by 52% of Texas women, 58% of Latinos, and 51% of millennials, actually. It was interesting.
But Peter, what about the enforcement? What about the enforcement mechanism? Does that sound constitutional to you? I mean, some people have described it as a bounty.
But we do this, so here's the thing. What they did was they took some things, existing structures in the law. So for environmental issues, we allow private people to go and sue even though they might not have been the ones harmed for false claims. So that's fraud against the government. You can go and sue even though you weren't the one that was defrauded, the government was. So we called it a private attorney general statute. It is a unique statute though, because the issue here is abortion. Because of this uniqueness of abortion, they've been taken. The problem is if the Supreme Court had not read abortion into the Constitution uniquely, they wouldn't have needed to go to these different lengths in Texas. You're not going to see that in all of the other instances where there is an ability to develop law.
All right,
So
Carolyn,
I
I want to get you a chance to respond here.
Yeah, I think this is not an accurate analogy. The other cases in which people can exercise the interests of the state actually can step in. In this instance, the state is actually expressly prohibited from stepping in. Why? To prevent federal court review of the law. It was designed that way. It was designed to create a chilling effect under which clinics would stop providing abortions, which is what has happened in Texas. And people can sit back and say, well, it's not really violating people's rights because the state's not doing anything. And at some point, years from now, maybe there will be a resolution in the Supreme Court. Now, it's perfectly understandable when states we see this happening a lot. In fact, the Supreme Court a month from today will be hearing a case out of Mississippi where Mississippi has passed a law outlawing abortions as of 15 weeks. I don't know what the Supreme Court is going to do in that case. As a person who supports reproductive rights, I have to admit I'm not very optimistic. But that's an appropriate way of asking the federal courts to consider whether or not they want to revisit the longstanding precedent, as opposed to this kind of underhanded outsourcing of violating people's rights.
Multiple cases on abortion before the Supreme Court potentially. Let's hear what Justice Kavanaugh had to say about an amicus brief that brought up that slippery slope argument.
It could be free speech rights, it could be free exercise of religion rights, it could be Second Amendment rights. If this position is accepted here, the theory of the amicus brief is that it can be easily replicated in other states that disfavor other constitutional rights.
Peter Breen, does that argument have merit, that it is a slippery slope to perhaps Second Amendment cases where a state might say, well, private citizens can bring lawsuits against gun owners or something like that?
Well, the idea of it generally being a slippery slope would work if those other areas were places where you were seeing a lot of judicial intervention, such as in the abortion space that we've seen over the last 50 years since Roe v. Wade. They don't really need to do that in those other spaces. And so that's as a practical matter, you're not going to see that done. As well, there is a judge in Austin, Texas, state court judge, that already issued an injunction against this law. The problem is there are individual plaintiffs that can bring the case, but I haven't seen a single case where the law was allowed to go. So it is a very different situation. They've taken a unique tack. Maybe Congress should change the law to allow these pre-enforcement challenges, but right now Congress hasn't. And the people of the state of Texas, the majority, are happy with their law and the way things are going.
Carolyn,
why shouldn't they be able to do what they've asked, what they want to do?
The people of the state of Texas don't get to decide if somebody's rights are going to be violated. That's the way rights work. So if the Supreme Court decides that it's going to reverse 50 years of precedent and overturn Roe versus Wade, it may well do that. But until it does that, it remains the law of the land that women have a right to obtain medical care, and both the intent and the effect of this law is to make that impossible. The reason you haven't seen cases going forward is because the clinics stopped providing abortions.
All right.
There are, in fact, so there's nobody to sue because the people who would be the defendants.
I'm sorry to cut you off. This is obviously a very weighty issue, but we have to leave it there. A lot to discuss, and perhaps a decision in the coming days and weeks on whether to take up this case and hear further arguments. Our thanks now to Carolyn Shapiro and Peter Breen.
Thank you.
Thank you.